Hi friends, Lawyer Autumn Whit-Boyd here. Today I am back with another installment in our series for online course creators. This is part 2 of the just 2-part series on putting together an affiliate program for your online course or online products. If you've got software as a service, an affiliate program might work for you. So any kind of online business that you're running, an affiliate program is a great way to promote your products or services by having other people help you promote them to their audiences. So that's what I mean when I talk about an affiliate program. If you haven't already, this is episode 97 of the Legal Roadmap podcast. Go back and listen to episode 95. In episode 95, I covered some of the basics, some things that you need to think about before you launch an affiliate program, some different considerations you may want to take about who should be your affiliate, how you might want to pay them, other kinds of ways that you may structure your affiliate program. So that is a good groundwork before you come back and listen to part 2, which is going to be what we're going to go through today. So looking at my notes, let me make sure I said that correctly. Yes, I don't know why I had written down the wrong number. Okay, so today we are going to dive into the real nuts and bolts of your affiliate program agreement. So last week we talked about kind of some preliminary things you might want to think about, but today we are going to kind of get down into the nitty-gritty of actually setting up your affiliate agreement. So I'm going to start with my standard disclaimer, which is I am a lawyer. I am licensed to practice in Tennessee. I am not your lawyer. If you're listening to this, this is just information. Nothing that I'm going to go over today is legal advice. This is just meant to get your wheels turning, help you know what to think about, and give you a vocabulary so that if you decide to set up an affiliate program, you can either do it yourself if you're just getting started, or since this is a more complicated legal area, if you are wanting to hire a lawyer and work with them, you will at least kind of have a baseline of knowledge and understanding, and it will make you be a much more efficient user of legal services. So I have, 8 things I'm going to talk about today, but it's not going to be too long. A lot of these are pretty quick. So we're going to talk about 8 different things you might want to think about as you're going through and setting up your affiliate program. So the first thing that I want to talk about, and this is not actually about the agreement, but a lot of people in the online world where I work, where a lot of my clients work, will call these joint ventures, or they might call them partnerships when they are working with other people to promote their products or services. They might, or you may have heard them called JVs, so for joint venture. I would caution you that that is maybe not a great idea, because in law, a joint venture has a very specific definition, and it is even in some states going to be defined by statute or by law in cases. So my guess is if you are just doing an affiliate marketing relationship where you are wanting other people to help you promote your products and services, and you're going to pay them either a commission or a flat fee for doing that, then that is not really a joint venture relationship. Typically, a joint venture relationship is where 2 companies or 2 people are contributing assets. They're contributing either money or intellectual property or other physical assets. Could be real estate, could be any kind of assets. But typically you have both sides contributing some sort of asset, and then both sides taking on some of the risk. So if things go wrong, they are sharing some of the risk. That is not typically what I am seeing when my clients are setting up affiliate programs. They are typically my client, who is the one selling the online service or the online course, a community membership, a software, a service. Typically, my clients are basically wanting to own all of that, and they also are taking on pretty much all of the risk. So if there are costs or if there are expenses associated with the program, the owner is going to bear that entire burden. And the person who's the affiliate is really just kind of a marketing independent contractor. They are maybe sharing it with their audience. Maybe they're doing a webinar or they're doing a social media campaign to promote it, but they're not really taking on any risk. If the program does poorly, all they're out really is time, energy, and any money that they spent on their own promotional activities, but they're not actually bearing the expense of putting the program together, running it, doing, if someone were sued about it, they would likely not be a defendant in that lawsuit. So when you're thinking about a joint venture, it's typically a very different kind of relationship than I'm usually seeing with affiliates. So Again, I would just caution you, these words matter in law. And so if you, God forbid, ever did have to go to court over an issue with one of your affiliates, you would probably not want it to be called something that is not how you're treating it. So partnership and joint venture, I would avoid those words if I were you. Think about it as maybe a services relationship or an independent contractor relationship. That is really the type of relationship that we're putting together with our affiliate program. So that is number one thing to think about. Whether you want to call it a joint venture or partnership, I would recommend against it. All right, the second thing I want you to think about is it is super duper important because this is as I mentioned, a more complicated legal arrangement. This is really an area where I would highly caution you against not using a contract. I know that was a lot of negatives in a row. That is a long way of saying I highly recommend that you do use a contract and that it be in writing and then it not be just a series of emails, that it be really clear. Ideally, you should probably have the same contract for all of your affiliates, unless you want to tweak it a little bit, maybe with some, if you give more favorable commission structure to some, that's fine. But typically you're going to want kind of a baseline where everyone is following the same rules and regulations. That's going to make it much easier for you to run the affiliate program, especially if you're having a lot of affiliates. If you will just let, if you're publicizing this kind of far and wide, you're letting a lot of people sign up, it's going to be very difficult for you to administer 15 different sets of agreements, of terms that you have with your affiliates. So a clear contract is really a must in this situation. And I'm going to give you 2 points where I think a contract in this scenario really is going to help your program run better. So it's not just that you're putting everything in writing, which I think is always a good idea. It's not just that you want it to be clear and easy to understand, which I also always think is a good idea. But with affiliate marketing, you are really asking someone else to vouch for you. You're asking them to promote your products and services to the people who like and trust them. And so that is really asking a lot of them. You're asking them to put their stamp of approval on your products and services. And so if you start off that relationship by having a really clear process to sign up for your program, by sending them an agreement that's very clear and easy to understand, and it just sums up everything you've already talked about with them, it is going to show that you are a real professional. And I think when you are asking other people to promote you, the better they think of you, the better they're going to promote you. So it really starts you off on the right foot. And with an affiliate relationship, I think that's even more important than with a lot of the other relationships that we've talked about, like working with contractors or even with your own students, because your affiliates are really kind of putting their neck on the line for you. So starting off on the right foot, they are going to, I think, take you much more seriously. And I think they're probably going to promote you. They're going to put more time and energy into promoting your products and services if they really believe that you are a true professional. Because what you're showing them by having a strong, clear, easy to understand contract is that when you deliver your services or your products to their audience, it's also going to be exactly what you told them you would do, and you're going to be professional about it, and it's all going to be a very high quality product. So you're really laying the stage for a more profitable affiliate program by having a good contract. It really, I just can't say enough how much this sets the tone for the whole relationship. It shows that you are a high quality, high value service provider or product provider. So using a contract, not just a must, but also it's probably going to make your program run better. All right, number 3 that I want you to think about. I talked about this a little bit in the last episode, so I'm not going to get too deep, but the first section of your affiliate contract, I suggest, should just go over what you're asking your affiliates to do. So if you have a very specific launch plan or a marketing plan that you're sharing with them and you're expecting them to do certain things on certain days, that should all be in the agreement. If it's a little bit more loose and they can kind of do whatever they want, then that should be in the agreement, that they kind of have their discretion to do as much or as little as they want. But if you are doing, let's say, a 3 or 4 week launch with very specific target dates for certain activities to happen, that all needs to be spelled out. You just want it to be very clear what everyone is agreeing to so they know on the front end what your expectations are. Especially if you are either requiring or asking them to create some sort of bonus that will be offered to their students. Whatever requirements or rules or requests you have around that should all be in the agreement as well. And if you're not familiar with affiliate programs and how bonuses work, go back and listen to last week's. I went into that a lot more. So number 3 tip is spell out very clearly what exactly you're asking them to do. Are you asking them to do a webinar? Are you asking them to do 5 social media posts within a 3-day period? Are you asking them to send out 6 emails to their email list? Is there a certain number of anything that you're asking them to do? Just really, really clear, and put it in writing. Put it in your agreement. All right, number 4. This is where the intellectual property gets a little bit tricky. So with an affiliate program, typically, if it's an online course with a more of a launch style, then this is going to be the case. If you're just signing up to be an affiliate of like a software service or something that is a little more high level with lots and lots of potential customers, this might be a little different. But typically, with an online course or program that's just doing a launch with a specific amount of time, you, the company who is running the affiliate program, so the person producing the product or service, you are typically going to be giving your affiliates what's called a license. And that just means you're giving them permission to use your intellectual property. And you want to spell out what exactly they're getting the right to use in your affiliate agreement. So what I typically see here is you're giving them the right to use your brand name. So any trademarks that you might have in your company name, your product name. You may be giving them the right to use your logo, and this is all so they can promote your stuff, right? It's hard to sell someone else's program if you can't use the name, or it's hard to tell someone, go check out this awesome online course, and you can't use the logo. So you want to give them permission, but typically you want that to be a kind of limited permission. You're not giving them carte blanche to do whatever they want with your logo or your brand name. You want them to just use it in this promotional capacity with this specific launch or within this specific time frame, or maybe just it's an ongoing, an evergreen, open all the time product, but you only want them to use it with relation to that product or that promotional effort. So that is the first license. So you, the person who is the owner of the course or the product or the service, are giving your affiliates a license to use your branding. You may create images as part of the launch, or for promotional materials, you may give them copies. So you may give them email drafts or social media posts or other kinds of wording that they can use. So you want to make clear that they have permission to use all of that. That will give them some confidence that they're not going to get in trouble. You're not going to come after them later for using your intellectual property. So that's the first license. The second license that you might want to think about is a license from your affiliates back to you. So let's say one of your affiliates creates a really cool video promoting your course, talking about what an impact it had on their life, or they create a series of emails where they do a case study and they walk through how it applied to a certain area of their business or of something else. It can be really helpful to your business to now be able to use that material in your next launch. Maybe that now becomes a testimonial that you use in your marketing materials. And also you may want to use images of them. Let's say you have a physical product. I'm just going to hold up, this is my Tervis tumbler. If you're selling a physical product, maybe people are promoting your products on social media or on their website, and they take images featuring your product. You might want permission to use those images in your marketing. And so you need to get permission to do that. You want to make that clear that if they are creating images that are part of the launch or part of their promotional strategy, that they are also granting you permission to use them. And that just means it's all very clear up front, and you don't have to, a year later, when you're doing your next launch, go back to them and say, hey, I loved that promotional material you did for XYZ. Can I use it? And then they say no, or they're hard to find, and so you're not sure about it. Makes it very clean and simple on the front end. So something to think about is, do you want the license to go both ways, where you have permission to use their stuff, they have permission to use their stuff? Something else I want you to think about is, do you want to require that they get your approval before they do certain things with your brand or with your logo? So could they, for example, create an image that has their logo kind of meshed with your logo to show that your brands are affiliated with each other? Or do you want to be able to review and approve any kind of materials like that they're creating? Do you want to have a right to approve before they're putting out new stuff? Or are you going to send them everything that they are allowed to use, so you really don't want them creating anything? Again, there is really no rule or requirements about what you can and cannot have in an affiliate agreement. It's just what two people will agree that they think is a good idea. So these are things I just want to kind of get your brain working on that you might want to include is a right to approval with use of your brand. I mentioned also in the last episode about affiliate agreements that if you are providing things that you would consider confidential in your business, you may want to consider asking your affiliates not to disclose those. So including what's called a non-disclosure clause or an NDA, just something to think about. With a lot of affiliate programs, you're not really sharing anything. But if you've got a core group of affiliates that you are kind of inviting behind the scenes of your business, they are seeing your marketing plan, they are kind of in the mix with everything that you're doing, and you wouldn't want them to then go tell a competitor, hey, this is how Autumn runs her launches. They're really cool. This is exactly what she does, and I can walk you step by step through them, or sending them a copy of your marketing plan. If there are things that you want to safeguard, then you might want to include a confidentiality or sometimes called non-disclosure NDA term. That was kind of a bonus. That wasn't even one of my numbers. So that was kind of 4.5. All right, so that was number 4, was thinking about the intellectual property and what you are licensing, what you are giving each other permission to use. Number 5 is payments. So how are you going to pay your affiliates? Are you going to pay them a flat fee or a percentage? I went over in the last episode some things to think about there, so I'm not going to delve too deeply into that. But just from a logistical standpoint, you want to include in your agreement, how exactly are people getting paid? Are you sending them a check? Are you paying them by PayPal? Is it happening once a month? Or is it happening once a quarter? Is there a certain minimum amount of affiliate commission that they have to earn before you're going to pay them out? You don't necessarily, especially if you're sending a paper check, and if you have a smaller dollar product, you don't necessarily want to have to be doing $3 payouts. So you might want to say it has to be $50. Or I've even had affiliates who have really large, clients who have really large affiliate programs who have like $1,000 or $1,500 minimum. So your affiliate bank has to get up to that point before they'll do a payout. And that's just for you to think about, because you are going to have to administer this program. And if you've got 100 affiliates, just the administrative headache of figuring out how much everyone is owed, running the payments, making sure all your accounting is correct, sending them statements, it takes time and energy. So you may want to think about having a minimum level before you have to go through all that trouble. So think about how you're going to pay. Some people do PayPal, some people send checks. You can do electronic transfers. There's all kinds of different ways. Are you going to do a percentage or a flat fee? When? Something to think about here too is if you have a refund period. So for the bundle that we sell with the law firm for online course creators, we have, I'm going to say it wrong because I haven't looked at it. I think it's 45 days, a 45-day refund period. Where you can try the templates, you can give it a shot, you can go through all the content, and you can participate in one of our monthly Q&A calls. You can be in the Facebook group, and if after 45 days you decide it's not a good fit for you, we will refund your money. So for my affiliates, I need to wait past that 45 days before I pay them their commission, because I don't want to pay them a commission on someone who makes a refund request, because that means I'm actually losing money. So think about that if you do have a refund period or just a refund policy, how that might play in with your affiliates if you want to give yourself some sort of delay so that you have time to see what refund requests come in and make sure that you're not paying out commission on payments that you're actually refunding. So that was number 5. Think about how you're going to process payments, how everybody is going to get paid. That's what is the most exciting part about being an affiliate, of course. Number 6 is technology. So there are lots and lots of different ways that you can run an affiliate program from a technology standpoint. There are many, many plugins, many services, many pieces of software that you can use to run your affiliate program. But the basis of any affiliate program is there has to be some way for you, the business owner, to track which affiliate sent someone to you. So what I see most commonly is people are using a software that will put a cookie on someone's computer after they visit the affiliate's link. So each affiliate gets a specific link that they use to promote the product or service. If someone clicks on the link and then goes and buys it, the cookie kind of tracks, okay, they came in through Jenny's link. So I know I need to pay Jenny for that person's purchase because that's how they came to me. Some people will use instead a specific coupon code, and so you can track how many times the coupon code has been redeemed and for what value. I'm sure there are other ways. Those are the two most frequent ones that I see. But you need to have some way to track how people are getting credit for their referrals. So whatever you choose, you can investigate and decide on your own what is the best tech for your own situation. But you want to just make that clear, again, in the agreement, how that's going to work. So if there are any questions, I think the trickiest thing here is what if Bob is scrolling Facebook and he clicks on my link and he goes and he looks at the, let's say it's an online course. He goes and looks at the online course. He gets to the sales page. He doesn't buy. He gets distracted. He goes and, maybe he's cooking dinner for his family or he's doing something else. He comes back. He's on Facebook again and he clicks on someone else's ad. He clicks on Sarah's ad. And then he goes and purchases. So with most affiliate programs, the last link that you click on is the one who's going to get a referral fee. So again, you just maybe want to spell that out so that if he had a previous relationship with someone and they thought that he was coming in through their link, but he ended up clicking on another, just say it's the last link clicked, or however your tech works. This could be different for different people. But you want a clear way to track and make sure that people are getting credit for the referrals that are the buyers that they're sending to you. So that's number 6. Figure out your technology and just make sure that your agreement matches your technology and how all that's working. Number 7 is termination. So we never want to think about this. We always want things to go really well, but either side may decide that they do not want, either the affiliate maybe doesn't want to be an affiliate anymore, or the company does not want them to be an affiliate anymore, either because they've changed their program or the person has misbehaved. It may just be that they're going in a different direction. There could be lots of different reasons for this, but you want to make it clear in your agreement how can either side end the relationship. And what I see sometimes and what you might want to think about is even having kind of a limited term for each affiliate agreement, especially if you were doing launches just once a year. You might want to think about this. So someone signs up and they're an affiliate for one launch and then they're kind of done after that launch. And if they want to do the next launch, they either have to be invited or they have to apply. So you can kind of take a look at your whole group of affiliates with every launch. That works really well if you are trying to keep your group of affiliates smaller, and you can take a look at the numbers from your launch and see who really hit it out of the ballpark, who did a really great job promoting your products and services, and maybe who didn't put very much time and energy into it, didn't sell very much. Because again, the more affiliates you have, the more work it is to administer the affiliate program. So you want to make sure that the people who are your affiliates are kind of carrying their own weight. You want to make sure that they are worth the time and energy that you're putting into helping them sell or promote your products. Again, unless you are maybe a software service that you want a very high volume of affiliates, then maybe it's great for that to just be kind of never ending. But if you want it to be a little bit more of an exclusive club, then you want to make sure you have the right people in there. And a great way to do that is to go ahead and have that term end. That also gives you the opportunity to take a look at your program with each launch and maybe change some things. And that will mean you need to update your agreement anyway, and you probably need to get everybody to sign it again. So, that's a nice way to just make sure you have a fresh start with every new group of affiliates and that everyone is on the same page, that you don't have some people with the old version and some people with the new version. That can be really tricky. So however you decide that you want people to be able to terminate, either they want to leave or you want to kick them out, you can specify if there are things that would make you want to kick them out, or you can just say, the business has discretion to terminate any affiliate at any time for any reason. I do think it is a good practice in that scenario to go ahead and pay them out any commissions that they have earned for sales to the date of their termination. And you might want to say, of course, that payout may be delayed due to the refund period, that's all still going to work the same way. It's not like you're going to pay them out that day. You're still going to honor the delay for the refund period if that is part of your payout system. All right, so that's number 7. How can either side terminate the relationship? And then the last thing I want to talk about, this is typically at the end of contracts, and it is one of those things that it is kind of long and boring. And even as a lawyer, I will admit I am sometimes tired by the time I get to the end of a contract, and I kind of gloss over and don't really want to read these carefully, but they're sometimes called general terms. The last couple things in any contract, I know they look boring because they are typically where the legalese gets put, but it can be really, really important. So these are things like, how are you going to resolve a dispute? If you have a disagreement with your affiliates, maybe they think they're owed some money and you think it should go to a different affiliate, or maybe they've used your intellectual property in a way that you weren't pleased with. There can be lots of different disputes, just like with any relationship in an affiliate relationship. So you want to go ahead and say, if we have a dispute, this is how we're going to resolve it. I do sometimes see arbitration clauses included in these kinds of contracts, and I would caution you to think carefully about that. If you are not a lawyer, if you did not write that arbitration clause, you should probably talk with a lawyer about whether it makes sense in your scenario. I find that typically with small business disputes, arbitration can be more expensive and slow. And so I don't typically include them unless there's a really good reason to do so. And there are some scenarios where it makes sense. But that is something where if you're going to include that in your affiliate agreement, I think that you should be talking with a lawyer, making sure it makes sense for your goals and processes for your agreement. But something I do want you to think about are, and these are going to be lawyer words, there's just no way around these kinds of legal terms. I try and use as little legalese as I can in my documents, but courts are going to want to see specific words for some of these. So one of them is jurisdiction, and another is venue, another is forum. So those all mean a little bit of different things, but without getting too deep down that rabbit hole, it matters because if you have a dispute and someone wants to sue the other person, that will tell you where you can sue, where you can be sued, and where you have to show up. So our court system has protections built in so that, let's say I live in Tennessee, I'm looking out at the beautiful Tennessee River out my window today. I can't be sued in California if I've never been to California, if I have no relationship with California, if I have not been doing business on purpose with California. Someone can't just make me go to California to be sued. But you can under a contract. Let's say I contract with a California company, let's say as an affiliate. I can agree by contract that yes, if we need to sue, it will happen in California. And so these are often called forum selection or venue selection clauses. It is really helpful to you as the owner of the business to have some certainty about if a lawsuit is filed, it's at least going to be on my home turf. So I know I can hire a lawyer that I've already got a relationship with. I don't have to go to California and find a new lawyer. And it also, frankly, is a bit of a disincentive for the person on the other side of the contract to sue you because let's say they're in Idaho, they probably don't know a Tennessee lawyer if it's me and I'm putting a forum or venue selection clause for Tennessee. So it encourages everybody to come to the bargaining table because it's going to be much more beneficial for me to file a lawsuit over this contract than it is for the other person. And I typically like for contracts to be very even-handed, but this is one area where I do think it makes more sense for the person who owns the business to have some certainty and to have some consistency in all of the contracts that you're not going to have to either sue or be sued in all these different states or countries where your affiliates may live, but that if there's a dispute, we're going to settle it in Tennessee, and I've got some advance notice. I can have a lawyer that I know. I can bring it in a court nearby. I'm not going to have to travel. So that is one of those terms that I would encourage you to think about. Again, it's in the boring part, but it's important. In that same category would be an attorney's fees clause. So in America, everybody bears their own legal fees, typically, unless there is a statute or you put it in a contract. We call these fee shifting provisions. So you are typically, whether you're sued or you are the one bringing the lawsuit, you are going to have to bear your own attorney's fees. But under a contract, you can change that. So typically the way we see that is whoever loses has to pay the winning person's attorney's fees. And this is just another way it makes it a little easier on the person who has to bring the lawsuit. If they know I have a solid claim, the other person really did something wrong, I know I'm going to have to spend some legal fees up front, but I'll get them back on the back end when I win. Again, it encourages everybody to come together. It encourages everybody to resolve their difficulties sooner rather than later because the loser knows they're going to be on the hook for attorney's fees, and that sometimes is more expensive than whatever amount of money was at issue in the first place. So in these general terms, just read them carefully. Make sure that you're including some basic ones. This is another area where it really pays to talk with an attorney and make sure you have the right things in your contract that are going to cover you for your affiliate program so that you are taken care of. All right, so those were 8 things. I know I've gone a little long on this, but I hope this has gotten your gears turning. And if you are thinking about setting up an affiliate program, I would love to hear from you. So our Legal Roadmap Facebook group is a great place to post any questions that you have about setting up your own affiliate program for your online course, your services, your products. You can go on Facebook and join that. Just let us know what kind of business you have. We do like to keep it a business owners group, or if you are thinking about starting a business, that works too. We'd be happy to have you in there. And we brainstorm, we answer questions. I pop in there a couple times a week, and other people are really helpful at answering questions as well. So definitely go join that group if you haven't already. If you enjoyed this type of discussion, that is the kind of things that we're talking about in the Legal Roadmap Facebook group as well. Next week's episode, I am mixing it up a little bit this season. Season 4 is all for online course creators. I've been speaking with successful course creators and also some of the companies that provide products and services to course creators. So next week is going to be my interview with the CEO and founder of Thinkific, which is an online course platform where you can post all of your content, your videos, your worksheets. You can organize it and help people get through it. So CEO of Thinkific, Greg Smith, he actually also, we had a really fun conversation, so you're going to really enjoy it. He is a lawyer, which is kind of unique. So we got to talk a little bit of his unique perspective on legal for online courses, since he has a background as a lawyer himself. He's not practicing right now, but he actually started his own online course, and that's what got him into running an online course platform. So he has a unique perspective from many angles, and you're really going to enjoy that. So that's episode 98 next week with Greg Smith from Thinkific. You don't want to miss it. And I will talk to you guys soon. Have a good rest of your week.